We have defended hundreds of lewd conduct cases, and I can tell you that almost always the client is able to avoid being convicted. It's very important for us, first of all, to maintain a very high level of discretion. Most of our clients, they want to be sure that their employer doesn't find out about this, that their family, that their domestic partner doesn't find out about this. And so we want to keep it as under wraps, as secretive as possible, and obviously make it go away in a very quiet manner, but make it go away not through pleading guilty, but through getting that charge dismissed. What we have to realize is that it is not inherently illegal to do something sexual in public. It's only illegal if there is a third party there who would be offended by it. You reasonably believe that there's nobody there who would be offended by it, and even if there was something sexual going on, it does not meet the legal definition of lewd conduct in public. A lot of times in these cases we find that the police officer either lies or exaggerates or embellishes the facts in order to build his case. And in a situation like that, we want to do what's called a pitches motion. We want to get the personnel file of this officer, and we want to see who has made complaints against this cop in the past. Because a lot of times we find that there have been dozens of people who have accused this officer of fabricating police reports, of lying in court, of making homophobic and insensitive remarks to suspects and other officers. And if we can get that sort of evidence, we can really demolish that officer's credibility. Our agenda is to see to it one way or another that you are not convicted of this offense. Whether that means that we can work it out through negotiations with the prosecutor or the judge, or whether that means we go to jury trial and we go for a not guilty verdict. We are determined to make sure that this doesn't go down on your record.